My name is Melissa Hart. I, for 18 years, was a professor here at CU Law School, and I'm now a justice on the Colorado Supreme Court. But for this year, I'm still going to be running our Constitution Day project because I think it's important to keep these activities going on. And it's a good way to get CU Law students out into schools and into the community to share your knowledge. I realize for you who are 1Ls, and a lot of the volunteers are 1Ls, you have not yet taken constitutional law, so some of this is new that you'll be learning now. But the way we've set it up is I've put together a lesson plan working with some law clerks and a law student that will give you all the information you need to talk to high school students about what this year's lesson is about the Fourth Amendment. And in particular, what we're looking at is how the Fourth Amendment applies in schools, with some contrast to how it applies outside of schools, because the Fourth Amendment, like the other amendments in the Bill of Rights, looks different in different contexts. And that's part of, sort of as we think about the Constitution, one of the things that we think about. And I'll say more about that. But so Constitution Day, the reason we're doing this is because on September 17th, 1787, the original Constitution was signed. And in the 1950s, President Eisenhower signed a law saying any school that receives any public funding has to do something to commemorate Constitution Day each September. I'm not sure, I think it's often honored in the breach, but we try to do that both as CU, a school that receives significant federal funding, and to support our Colorado public schools who are looking for Constitution Day activities. In the lesson plan, I'll explain that you could start by explaining that, by talking about Constitution Day. It somewhat will depend on the length of the class that you have. Generally in the public schools in Colorado, classes seem to sort into two lengths, what I call shorter classes and longer classes. So there'll be 45 to 60 minutes, that's kind of the shorter classes, and then some classes are as much as 90 minutes. It's a lot easier to spend more time talking, obviously, in a 90-minute class. In a 45-minute class, you basically got to get right into the Fourth Amendment and our Fourth Amendment cases and the hypothetical. Because the way this lesson is structured is around the sort of the fun part for the students, and the part where they really engage and interact is talking about the hypothetical that we've drafted. They can't do that without first having some of the constitutional text and the case law to work with. But getting through that constitutional text and case law is giving them tools to then engage themselves in the exercise. So we're sort of, that's what we're moving towards, and what the bulk of the class should be, is the hypothetical. Any questions about that? Okay. So,
Well, I'm sorry, actually, so you said it just requires all schools to do something during September to honor the standing Constitution? Okay, cool.
Yeah.
That's with that.
And schools do all kinds of things. So there are many projects where lawyers, the Denver Bar Association has a project where it goes into middle schools to talk about, I'm not actually sure exactly what they do, but this is sort of common for lawyers around the country to use this as an opportunity to engage with students. And this just happens to be the approach we're taking. So this year's lesson plan is, I also usually, let me interrupt myself and say, I usually explain to the students that although we're recognizing the signing of the Constitution on September 17th, 1787, most of what we're talking about did not exist in 1787 because we're talking about the Fourth Amendment. And then I usually ask the students, how do we know that the Fourth Amendment was not part of the original Constitution? And usually someone will say, because it's called an amendment, which means it's a change to the original Constitution. And if a student doesn't pull that out, then I say, you know, an amendment means this is something different. So the Bill of Rights, the first 10 amendments were added quite quickly after the Constitution was first passed, and were in fact anticipated at the time of the passage of the Constitution, and were a condition for lots of people of its passage. They knew they were coming, and that's why they voted on them. Again, in a longer class, I'll sometimes ask the students to talk about what rights they know are in the Bill of Rights, talk about for a few minutes about why these rights would be in the Bill of Rights, why did these seem particularly important. One thing I try to avoid getting into too much is the Second Amendment, because people have strong feelings on both sides of the Second Amendment. So that's, although it will come up almost immediately as one of the important rights. I sort of try to balance moving along and not getting trapped there. We're having a brief interruption. Oh. So after sort of talking a little bit about the Bill of Rights, what I'll do is move to this year, the Fourth Amendment, and put the text of the Fourth Amendment. Sometimes when I first come into the classroom, maybe write the text of the Fourth Amendment up on the board. As I explained before we started the tape, my computer was being glitchy today, so I wasn't able to print out this part of the lesson plan, so I'm reading from my computer. But the text of the Fourth Amendment says, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." Lots of requirements in there, right? No unreasonable searches and seizures. There's the idea of warrants, and warrants that are supported with particularity. Usually high school students will have heard of both the warrant requirement and the unreasonable search and seizure requirement. In most of our high school classrooms, contrary to sort of popular lore, students actually are getting a pretty good civics education. They don't necessarily remember it, but they will have heard of this before. So a lot of what we're doing is kind of jogging their memory. What is an unreasonable search and seizure? And through talking about that, how would you decide what's an unreasonable search or what's an unreasonable seizure? Kind of starting to get the students to pull out this idea of societal expectations about when it's reasonable to expect privacy. We expect privacy in our homes. We have the idea that the government shouldn't be able to walk into my house without some justification, without a warrant, because that's a place where I expect privacy. The government shouldn't be able to open up my car and go through my car. Do I have the same expectation of privacy in my car that I do in my home? The answer is probably not under the law, and students usually get that. And then you can start to talk a little bit about, so what about in school, which is again where our scenario takes place. What about in school? You walk into the school, do you give up all your rights to privacy in a school? And the answer is no, but there are lines, right? What about things that you put in your locker at school? Most students will say that they were told when they first started school that their locker is school property and they don't have an expectation of privacy in their locker. But you can sort of start to run through, and the lesson plan will set out some examples of scenarios that you can set out. What about in the pockets of something that you're wearing? Do you have a reasonable expectation of privacy that someone's not just gonna put their hand in your pocket and pull out whatever you have there? What if you take your jacket off and put it on a chair? Or take your backpack off and put it on your desk and leave it there? Does your expectation of privacy change? So students, again, because this is where they are, they're in school, they will have ideas about it and sort of a sense of what their expectation of privacy, what they do expect, and then you can talk about whether that's reasonable. And the idea that we're trying to tease out is that the Fourth Amendment, the words are fixed, but its application requires some assessment, particularly think about the word unreasonable, requires some assessment that's more, that's both subjective and objective, that reasonableness is something that we have to measure based on the circumstances. We have to end up with some kind of an objective standards. There have to be some rules because the police need to know or a school needs to know what the rules are, but they're moving targets. So some conversation about that for just a few minutes, and I would say the whole conversation about the Bill of Rights and Constitution Day and then sort of the Fourth Amendment, I would say 15 minutes about when you're sort of thinking in your mind, particularly in a shorter class. Then we have two cases, and again, I apologize that I don't have the handouts for them today, but I will tell you the first case is a case called New Jersey versus TLO. New Jersey versus TLO is the case that establishes what the Fourth Amendment standard is in schools. And it establishes that the Fourth Amendment applies quite differently in schools than it does when you're out on the street. So we know that when you're, or in your house, when we're in your house, you know that the police need a warrant to come into your house. You don't need to get into unless it's one of the circumstances that allows them to not have a warrant, because there are exceptions. But this idea of the Fourth Amendment's warrant requirement doesn't actually apply in schools. And this was established in this case from 1985 called New Jersey versus TLO. The students will have been given short summaries of the two cases that you're going to talk about ahead of time, and I've asked the high school teachers to have them read these cases as homework beforehand. Most of the time that will happen, so most of the time you can expect the students to be somewhat familiar with the cases. Sometimes this is going to be the first time they've seen the cases and you're going to have to walk them through it. I find a good way, they're very short summaries, the two cases fit on one page. I find a good way to go through the cases with the students is to do sort of popcorn reading, have people around the room read so that everybody knows they might be called on to read. Some classes you'll have great volunteers who want to. Some classes you will have to say, hey, would you take the next paragraph? If you have time to check in with your teacher beforehand and ask if there are students who are English language learners or particularly shy and who wouldn't be good candidates for reading, I recommend that. But usually you can tell. It's usually pretty clear who are the students who are backing away from being called on and who are the students who are looking you in the eye and seem to be engaging and are good candidates for being called on. So in New Jersey versus TLO, a teacher caught a couple of students smoking in the bathroom, which was a violation of the school rules. One of the students said, no, I wasn't smoking. And, well, the teacher took the students to the principal's office. One of the students, who is TLO, we use her initials because she was a minor, and so we don't put her name out in public. She denied smoking. The principal said, hand over your purse. I'm going to look in your purse to see if you have cigarettes there. He opened her purse. He saw cigarettes. He also saw a packet of cigarette rolling papers, which he associated, he knew that in the school, oftentimes people who had rolling papers were using marijuana, and were using the rolling papers to roll marijuana cigarettes. So he decided he was going to search further to see if he found evidence of drug use. He did find evidence of drug use, and not only drug use, but drug dealing. He found a small amount of marijuana, a large wad of cash, and what seemed to be a list of students who owed TLO money. So he turned all of this over to the police, and TLO was prosecuted for dealing marijuana on campus. She challenged the use of the evidence in her trial, and she said, and this is a judicially created remedy for if there's a Fourth Amendment violation, if the police engaged in an unreasonable search or seizure, or the state, so in this case the principal, engaged in an unreasonable search or seizure, then courts will say the evidence that you got in that unreasonable search or seizure can't be used in the trial. And one of the things that actually I think it's helpful to pull out is, why would TLO not want that evidence used at trial? And it usually takes students a little bit to think of it. It doesn't mean she can't be prosecuted. No, it doesn't mean she can't be prosecuted. The state can still bring the lawsuit against her. But what's the lawsuit going to look like if they can't use any of the marijuana or money or list of people who owed her money that were taken from the purse? It's going to be much harder for the prosecution to prove that she was dealing drugs. So the reason she wants it excluded is because even though she might still be tried, she has a much better chance of getting off. And the reason the state wants to include it is, with that evidence, it's a pretty easy case, and without that evidence, it's a pretty hard case. So that's why it matters, why they argue about it. So this case went all the way to the Supreme Court, with TLO saying this evidence should be excluded because this search was unreasonable. The principal didn't have a warrant, and you have to have a warrant, and it was an unreasonable search. And the Supreme Court announced the rule that searches in schools don't have to have warrants. Usually I stop at this point and ask students why. Why would the court say students in schools don't have to have warrants? Any thoughts in this room? Why would we say a school doesn't need a warrant to search?
So the school has a need to exercise a greater degree of safety and control over their students as compared to a, private home.
Okay, good. Yeah, the school, when you look at who the government actor is. So in this case, it's a principal. It's not a police officer. He's not coming to arrest you. The school has a job. The school's job is to get students educated and keep students safe. And in order to do that job, the school is sometimes going to act different than a police officer on the street or a judge. The school is going to have to act quickly. If the principal every time the principal wanted to search a student who he suspected was breaking a school rule or violating the law, had to go to court and get a warrant, that would be very disruptive to running the school. That's, whereas police have regular access to magistrates who issue warrants, that's part of their job. That's not really part of what a principal does. So the court said, a warrant requirement isn't going to apply in schools. But there still is an assessment of whether a search is reasonable. Another thing that doesn't apply in schools is principals don't have to have probable cause, which is the standard for police. And it's the standard that almost certainly most of the students will have heard of. They'll know about probable cause to search. This is a lower level of search, again, because of the school's need to keep kids safe and keep things moving. So to search, for a principal or a teacher to search, they have to have a reasonable suspicion. That's the standard. What's the difference between probable cause and reasonable suspicion? The only thing we know is reasonable suspicion is something less than probable cause. So it's a little fuzzy, but you have to have a reasonable suspicion, and there's a two-part test for that. It has to be reasonable at the start of the search, and then the scope of the search has to be reasonable. So, for example, in New Jersey versus TLO, if the principal, it was certainly reasonable for the principal to look in the purse for the cigarettes because the teacher had seen smoke billowing out of the bathroom, and then TLO walked out of the bathroom and TLO said she didn't smoke, so the principal looked for cigarettes. That was one search. That was quite reasonable. There was then this next search, which is the principal saw the rolling papers and continued into the purse. So was it reasonable when the principal saw the rolling papers for him to suspect that drug dealing might be going on, or drug use might be going on? It's debatable. Part of what happens in these school search cases is principals are allowed to say, based on my experience as a principal, I have seen many instances where rolling papers were used at this school by students smoking marijuana. So yes, the court here ultimately said it was reasonable when he saw the rolling papers for him to then look for other evidence of drug use. He then looked in her purse. He didn't look any further. He didn't say, let's go out to your car and you are gonna let me go through your trunk. He didn't say, take off your clothes, I'm gonna strip search you. He just looked in her purse. That's the scope piece. The search was reasonable in its scope, given his suspicion that she might have drug paraphernalia beyond the cigarette papers. So that's the test, reasonable at the start and reasonable in its scope. So that's the first case that the students will use to think about this hypothetical. The second case is actually a case from the Colorado Court of Appeals. And part of why we included this is because it's interesting for the students to think about how the constitutional rules are made by the US Supreme Court, but then courts in the states have to apply them too. So the Constitution applies both in the federal court system and in the state court system. And when a state court is thinking about the Constitution, it's looking at what did the US Supreme Court do. So People versus Amwanda is the second case. It's a 2014 case. And an important thing that happened in 2014 is there was another Supreme Court case, US Supreme Court case, in which the US Supreme Court said to search the contents of a cell phone, to go into the data on a cell phone, police have to have a warrant. We're not going to have them read that case because that's just too much to cover in a class. But in a case called Riley versus California, the court said, cell phone data, the stuff we have in our cell phone is so private. And there's so much of it. We keep our whole lives in our cell phones, really. More content in our cell phones than in our whole house for lots of people. In order to go into the phone and look in the data, police have to have a warrant. So after that case, the Colorado Court of Appeals decided this People versus Amwanda. Amwanda was stopped by the police. In his car, he had drugs and drug paraphernalia. A police officer took his phone and looked in his text messages without a warrant. Saw 3 text messages that indicated that he was a drug dealer. On the basis, then went and applied for a warrant to look at more stuff in the phone. But he used those 3 text messages, the content of those 3 text messages, to get the warrant. So he said, I saw these messages, so I think there's going to be more. And the magistrate who was issuing the warrant said, yeah, that seems right. That's probable cause. Now you can search the phone. So Mr. Amwanda said, well, because of Riley, because the Supreme Court said you have to have a search warrant to look at the data, he should never have looked at those first 3 text messages. And so all of the text messages should be excluded and shouldn't be used in my trial. The Court of Appeals said, it's true, those 3 messages shouldn't have been used. The police officer violated Mr. Amwanda's Fourth Amendment rights by looking at those text messages without first having a warrant. But the court did not throw out the case because the court said, but he had drugs and drug paraphernalia in the car and he was acting really nervous. So it's what we call harmless error because the police would have been able to get a warrant based just on those things without the text messages. So they let it in, but they still said that was wrong. You can't get a warrant based on a search that was unconstitutional to start with. So those are the 2 cases that the students are going to be working at. I think it's one thing I will say, I wish it hadn't been a harmless error case because I think that makes it a little trickier to make the point that we want to make, which is a second search based on an illegal first search may be illegal. And that's the point that we want to get out of it. Even if that second search would be okay if the first search had been okay. So with that background, we then give the students the hypothetical. Our hypothetical this year raises a topic that, again, students think about a lot and talk about a lot in schools today. A couple different topics, but the big sort of underlying topic is a question of bullying in schools. And the hypothetical supposes an app called Chat. It was originally in our hypothetical called Chit Chat, but it turns out there is an actual app called Chit Chat. So we took that out. It's called Chat. It's a smartphone app that lets users post anonymous messages. The messages are visible only to other users within a half-mile radius. So you can sort of be talking to people who you know are in the building, but other people outside of that half-mile radius can't see it. Again, this is just hypothetical. I don't think such an app exists, but it might. Does it?
It does. Yik Yak, although I don't know if it's still in use.
Okay. Well, so high school the hypothetical supposes that high school students love to use it, but there are real concerns about bullying because you can say things about people in your school and other people in the school can see them and comment and feed on each other. And because of its anonymity in particular, there are concerns about bullying. So again, in our hypothetical, we have a student who's a new freshman at Metro High School, Naila Ibrahim. She's Muslim and she wears a hijab. And soon after she started her school year, she saw some posts on Chat that she was worried were about her. And the posts, and there are 3 examples that are given in the hypothetical. The posts say, for example, someone should tell her this is America, dress normal, or go home. Saw that freak at school today, at least I think I did, couldn't tell through the bag she wears on her head, LOL. And then a third, again, suggesting hostility to Islam and some kind of threatening language. So she shows these posts to her parents because she feels like they must be about her, or she feels worried about it. And the parents say, we're going to go talk to the principal. They go and talk to the principal. Principal asks Naila if she has any idea who might have posted them, and she says she doesn't know, but she thinks it might have been one of her classmates, a gentleman named Ted Hogan, because he had looked at her in a way that she thought felt very hostile in several classes. So based on that report from Naila, the principal calls Ted Hogan into his office and asks if he knows anything about the messages. Ted says, I've seen them, but I didn't send any of them. And the principal feels like Ted seems very uncomfortable, suspects that he might be lying, and says, I'm gonna need to see your chat app. Give me your phone, open up your chat app for me, and if you don't, you'll be suspended. So Ted unlocks his iPhone and opens the chat app history. The principal sees that Ted had in fact posted at least one of the messages and some other messages that used pretty hostile language. The principal says to Ted, look, I'm gonna have to reach out to your parents because you have definitely violated our anti-bullying policies with this kind of posting. That's that. So that's that interaction, right? So the first search that is at issue here is the principal's search of the phone. I think you could stop at that point and ask the students to start thinking, was it okay for the principal to search Ted's phone based on that? And again, we're applying New Jersey versus TLO. We're asking the question, did the principal have reasonable suspicion at the beginning to demand that Ted open his phone? And then was the scope of the search reasonable? So how would you analyze that given the facts that we have? Connor, what do you think? Was the suspicion reasonable at the start?
I mean, it's pretty weak because the fact that, she saw him looking at her hostilely, but there could have been any number of other people in the class who were doing so as well. Doesn't seem like it to me, just because that's really the only thing they had to go on is that they knew that he didn't like her, or they didn't even know that, so.
Right, so this is, I think, and part of why we wrote the hypothetical this way, we wanted to be ambiguous. I think there will be some students who will think, yeah, it seems reasonable. He was looking at her hostilely, the principal thought he was nervous.
That's true.
So I think this is a moment where you can get some good debate going. How many people think the search was reasonable? Tell me why. How many people think the search wasn't reasonable? Have that conversation. Because there's not, honestly, this is one of these areas of law where there's not a right answer to this question. Different judges would see it differently, different students will see it differently. I do think when you're thinking about the question, you should pull out what are all of the facts we can think of that make the search reasonable. So Nyla's report could make it reasonable. The principal's experience with students and his sense that Ted seemed to be acting uncomfortable and he suspected Ted was lying. On the other hand, wow, so you're going to let one student define what a hostile look is and put another student in the position of being accused of bullying? Is that really reasonable, or is that sort of too much circumstantial evidence? So I think you could go both ways on that. How about the scope of the search? How do we think about the scope of the search in this case? All he looked at was the chat app. That seems, I think there's a really easy case that the scope of the search, if it was reasonable for the search to happen, then just looking at the chat app was just what the principal should have done. If he had said, I'm going to go look at your other text messages and your photos and your email and really go through your data on your phone, that definitely would have been unreasonable on scope. It would have been beyond what any allegation was. But here he really limited it to what the allegation was. So maybe one flaw with the hypothetical is that we didn't add further searches, but as soon as he went further, I think it would then immediately become unreasonable. So the real question here is, was there sufficient suspicion for a search? And that's sort of where you might want to keep the students. Okay, so maybe after a little discussion of whether that search was reasonable going on in the hypothetical, later that night, the night that Ted Hogan was brought into the principal's office, someone throws a brick through the window of the Ibrahim house. And the brick has on it, on one side, an American flag, and on the other side written the words, "Snitch on this." The Ibrahims, of course, reported the vandalism to the police, and when they did, they mentioned to the police the conversation they had had with the principal the day before, and the chat app, and the messages that had been on it. So the police called the school, and the principal tells them about the messages he had found on Ted Hogan's phone. On that basis, the police investigators go to a judge and get a warrant to seize and search Ted's phone. The warrant is issued, and they search his phone, found that the chat app and all of its data had been deleted, but they found a photo of Ted holding the brick that had been thrown through Ibrahim's window. So they searched beyond the chat app, but they had a warrant. Ted was charged with violating Colorado's bias-motivated crimes law. At trial, his lawyer argues that the principal's original search of Ted's phone had violated the Fourth Amendment, and the police warrant was therefore invalid because it was based on the results of the principal's illegal search. Therefore, all evidence should be suppressed. How should the judge rule? So again, we're coming back to the question that we sort of touched on before, which is, was that principal's original search invalid? But you can then highlight the next level of the question, which is, okay, let's say the principal's search was invalid. Let's say that the police should not have gotten the warrant based on the messages that the principal described seeing in the chat app. Would they have any basis to get a warrant for Ted's arrest without that? Or not arrest, to search Ted's phone, excuse me. Was there other stuff that they might have had, sort of that it's similar to the Amwanda case? They could have gotten a warrant in any event.
So in the initial encounter with the principal, I guess this is one thing that I'm not necessarily clear on. Did Ted in the end admit to doing it after the principal saw his admit to the messages?
Well,
and
one
if
of
so,
the
would that be
messages
admissible?
was sent by him. I mean, the principal could see that it was sent by him.
But if Ted made a statement as a result of that search that was illegal, or the search was illegal, then would that statement also be thrown out? Or could he say, well, the first search was illegal, so we can't base the warrant on the chat messages, but did Ted make a statement to the principal that...
So the hypothetical doesn't say. Would that make a difference? Ted's statement would probably still have been based on the illegal search, so it probably would still be a problem.
Okay.
What other things might the police be able to base a search on?
So we have the parents and this child communicating to the police that, hey, we think it might be this person my daughter's been having a problem with in school. Or irrelevant to the fact of a principal searching something. We just say, hey, there's this bully in school that's bothering my kid. Do you think he might be behind this?
Right. And that, I mean, so to me, as I look at it, I think the chat app makes it much easier, just like the text messages on Mr. Amwanda's phone made it much easier. But Nyla and her parents told the police, yesterday we snitched on this guy, Ted Hogan, that Nyla thinks might be bullying her. And so the police could also, based on purely on Nyla and her parents' report, likely have gone and gotten a warrant. Would it be as clear a case? Definitely not. But might they have been able to get the warrant? Perhaps. So again, I think there's not an answer to this question. It's an opportunity to debate and to think about, do we like the idea that they might have been able to get a warrant? Would we rather say if the police use an impermissible search to get a warrant, there should be some kind of punishment just for that? Even if they could have otherwise gotten a warrant, the fact that they kind of went around the rules, maybe they should be punished for that, and maybe not. And again, people will have different views about that. I don't think there's a here's the answer. The answer is 5. That's not what this kind of problem is, and that's part of what I think it's interesting to get the students to start to see is there's some kinds of problems in the world that there's an answer to, and then there are problems like this where it's squishy. And that's part of the fun of legal argument and analysis, is that you get to these places where there are good arguments on both sides.
So if a judge were to rule that the police still could have gotten a warrant just based on the testimony of Nyla and her parents, but that the first search was illegal, that would fall into that harmless error? Gotcha.
Yes. And there I can say, I understand now in a way that I did not before I joined the court, like the amount of stuff in the world that is harmless error is quite enormous. There are mistakes made quite frequently that courts then say, look, this was going to turn out the same way anyway, so we're going to acknowledge that and still affirm what happened. So that's the basic exercise. Any questions about it?
I'm assuming this, but we'll get the second sheet with the 2 other cases. Traditionally, can that be email or on the website?
Yeah. So in terms of
Okay,
in
cool.
terms of process at this point, I sent out a link to teachers and I sent out a link to presenters. I've got a whole bunch of responses from both, and my law clerks and I are gonna sit down over the course of the next week and find times that work for presenters and that teachers have times available. I will connect you, either I or one of my law clerks will connect you with the teacher whose classroom would fit for you, and will provide to both the teacher and you the lesson plan, all of it, with instructions to the teacher that we want the cases to be handed out ahead of time, and finding out whether, for example, in lots of schools, they can print out the materials for you. Some schools they can't. If that's the case, then I'll arrange to make a copier available to you so that you can make copies. Or I might even just have copies available on the table upstairs. And that's just going to depend on which school and what their needs are. We'll also find out whether, do they have an easy space for you to write the Fourth Amendment? If they don't, the lesson plan will include the text of the Fourth Amendment, so if it turns out that it's going to make the most sense to print that out and have each student have that on their desks, that'll be a possibility. I find that's, given that the Fourth Amendment, the words are so old-fashioned, I guess might be a word, I think not spending too much time focusing on the text beyond unreasonable search and seizure and the idea of probable cause and warrants is advisable.
So if it's a 45-minute period, we should probably be getting to the hypothetical case by like 25, 30-minute mark,
Yeah.
somewhere in there.
You want to have 20 to 25 minutes for the hypothetical. So as you, whatever your class length is, if you assume that.
Mm-hmm.
And then in some schools, and again, this depends on the schools, but some schools really, the students really want at the end to have a chance to ask you questions about being a law student and why you went to law school. And in some classes, almost certainly, students will say, I have a cousin who had this happen. Wasn't that unreasonable? Didn't the police violate his rights? And there you should feel very free to say, I don't know. I can't answer that question because you don't know. But again, people's experience with law enforcement is all over the map. So I don't think I've ever visited a classroom and had no questions about, like, this happened to my brother or me or my cousin or my dad. So you just have to figure out a nice way to say, oh, that's interesting. I don't know what the judge would do in that situation, or what did the judge do in that situation? Do you want to share what happened in that situation? Rather than saying what you think should have happened.
And so, sorry, just real quick on the analysis. So in Amawanda, the initial stop and search was based on a text message? Or no, sorry, I just
So
missed a couple
the
details.
police stopped Amwanda, who had drugs and drug paraphernalia in his car. They picked up his phone and opened it and looked at text messages without having a warrant,
Okay.
but only at 3 text messages. And then based on those 3 text messages, got a warrant to search further into his phone and found more evidence. But because that initial opening it and searching the 3 text messages was a violation of his rights, that was the problem.
But they could have gotten the warrant for the whole phone search based on the other stuff
Based
in
on
the
the
car.
drugs and drug
Gotcha.
paraphernalia. If you're found with drugs and drug paraphernalia, the police are going to be able to get a warrant to search your phone. That's just a
Right.
solid general rule, because so much drug business is conducted on phones that that linkage is just tight.
Yeah, I read TLO as an undergraduate. I forget for what class, but yeah, I'm familiar with that.
Yeah, and a lot of students will have, again, they will have heard of it. They might even have read it or some version of it before. So much of what you're doing is just tweaking their memories.
Summarizing,
Yeah.
yeah.
Which is why we can use relatively short summaries for the cases. They will certainly not have heard of People versus Omwanda, because Colorado Court of Appeals decisions don't make their way into the classroom very often. Other questions? Do you each want to eat a whole pizza?
I'll take some with me.
Oh man, yeah.
Oh my gosh.
Some with you for the ride, for sure.
All right, well, thank you both very much for
Thank you.
coming. Thank you, anyone who watches this, for watching it. And I will be in touch with assignments and materials.
Thank you.
Thank you.
Thank you.